Judge Piet Koen of the Pietermaritzburg High Court recently ruled that a scorned wife was entitled to investigate the bank accounts of her husband's new lover. The matter arose in the divorce proceedings where the wife was suspicious that the husband was hiding money from her. Attorney and Senior Director at Clark's Attorneys, Bev Clark, joins us to explain the court's decision. We'll also be talking about other related matters in this interview. Bev, pleasure to have you with us here on the program. We appreciate this ruling by the Pietermaritzburg High Court generated a lot of interest, I realized, in the social media. It happened very recently, and we decided on the show that let's try and understand and learn a bit more why the court ruled in this manner, and is this a new ruling anyway?
It's not a new ruling, Tim. Generally, the court will assist litigants who are trying to find the truth. So if you have reason to believe, for instance, that your spouse has hidden money somewhere, as this woman believed, you're entitled as of right, as a litigant, to issue a subpoena against anybody who might be in possession of the documents that you want. And in this instance, the wife issued a subpoena against the bankers of her husband's girlfriend. And then the husband's girlfriend brought an application to say, I'm not a party to this divorce. I don't want my bank records looked into. The court said, well, you know, one has to wonder why she suddenly acquired 21 million rand in her account in the space of a year, in her bank account. And the husband and wife had been married for some 40 or more, 50 years or something. And the husband was pleading poverty. And the wife wanted to know where the money had gone. And generally in our law, the courts will assist you, as I say, to uncover the truth. And it is, the onus is on the person who does not want to provide the documents to persuade the court that they should not have to provide the documents.
But now, I suppose what makes this case interesting is the fact that the girlfriend is a third party in this matter, right?
Yeah.
And my limited understanding is that you could have such subpoenas against the party in the divorce matter, not a third party.
No, subpoenas are usually issued against a third party.
Against the third party,
yeah.
Okay.
So,
right.
I mean, when I say a third party, I mean somebody who's not directly involved in the divorce.
Yes.
So, for instance, the auditor of a company, or the human rights, the human resources person in a company, or a friend, or a subcontractor, somebody who might know something about the other party in the divorce.
I'm just imagining you first have to prove that a third party is a girlfriend or boyfriend in a relationship before the court could say, well, investigate, let's uncover what they have in their bank accounts.
No, you don't have to prove anything. You take you just take your subpoena, you draft your subpoena, you take it to the registrar of the High Court, and you say, please, will you issue this subpoena for me? And they put a stamp on it, and you send it off to the sheriff. So, no, you don't have to prove those things initially. You, as the attorney, are going to know whether there is reason to believe that somebody might have information which is of assistance. The information that you're looking for has to be relevant. So one of the very, very few reasons why a subpoena can be set aside is if you are using it as an abusive process, which basically means for an ulterior motive. So, for instance, you want to embarrass the other party, or you are using it just to try and force them to settle with you because, heaven forbid, you must go and look into the girlfriend's bank accounts. You know, then there might well be an ulterior motive, but not often. The court will very seldom set them aside.
So there was some basis then for the court to rule in favor of this, in the investigation of those bank accounts. What were the merits of that?
The merits were that the girlfriend was a nurse or a physiotherapist, and yet her bank accounts had her bank balance had climbed from, I think, about 6 million to 21 million in the space of a year. And that was at the same time as the wife had found in her husband's bank accounts that money had disappeared, and that he had been paying for fertility treatment, and she found out that the girlfriend then was having a baby. So all the pieces of the jigsaw puzzle fitted together. And the husband had also paid for the girlfriend's belongings to be moved to Australia, so the furniture removal.
Yes.
So clearly he was giving her money for some things.
Yes.
And so she had reason to believe that he might be giving her money for other things, or that he might simply be siphoning off money from his own account.
And obviously the intention here being not to provide her with a reasonable settlement in the divorce matter, I suppose.
Yeah, I mean, she's
asking for something like 30,000 rands or so a month?
That's for her maintenance.
Yeah.
So the husband is a medical specialist, so presumably he can afford her maintenance. But she is also entitled, obviously, to a capital claim. Because they've been married for a very long time, she's likely to get in the region of 40 to 50% of his assets.
Yeah.
So she needs to find out what his assets are and where they are. And if he is being cagey and he's not making full disclosure, or she has reason to believe that he's not making full disclosure, she's entitled to use the various avenues that the court rules provide to find out where the assets are and how much there is in his estate.
Now, the same can apply the other way around. Is it possible that the husband could ask for investigations into the wife's lover's financial accounts?
Very much so. Very much so.
It does happen
We
sometimes?
We do that fairly often.
Oh.
Yeah. Yeah, and so sometimes you would subpoena the lover or the alleged lover. You would subpoena their own bank accounts, and you can subpoena the actual person, or you could subpoena their bank. So if I know that that this girl is having an affair with my husband, I can somehow or another find out, for instance, I might see in my husband's bank accounts that he's making certain transfers to Nedbank. I don't know where those transfers are going. I could then subpoena Nedbank. And I could say to Nedbank, I want all the bank accounts of, Miss X Mazibuko, who I think has an account with Nedbank. And then they would supply me with the bank records. They would probably tell her, look, we've had a subpoena for your bank accounts. And she might then bring an application, which is what this lady did. In Judge Kun's matter.
Well, I suppose, using the current language that's out there in South Africa, people talking about blessers and blessees and so forth, that a wife can wake up and say, or should it be only in a divorce matter where a wife says, I suspect my husband is a blesser and I want to investigate the blessee and check whether she's receiving any money from my husband?
Yeah. It would only be in a divorce matter,
can only be in a
or in a
divorce
maintenance matter.
Okay.
So you go to maintenance court and save money for your child.
Yes.
You might not be married to the man, but he has a duty of support to the child.
Yes.
And he says, I've got absolutely no money.
Yes.
And then you look into his bank statements. You can subpoena his bank statements, and you find there are vast amounts that appear to be going out of that bank account every month.
Yes.
And if he won't tell you where those amounts are going, then you can subpoena further bank records of the parties who appear to be receiving his money. Because what you're trying to find out is why can he not pay maintenance for his child if he's managing to pay money somewhere else?
Now, there was another case before the courts, and you are familiar with that case, most definitely, the one of Sehwale.
Yes.
Right? I wonder what happened to it because it was out there in the public and some information was not being made public and it was going through different layers of the courts. And can you tell us a bit more about that case? Has it been resolved finally?
Unfortunately, it has not yet been resolved. We have an agreement amongst the lawyers that we won't discuss the details with the media, only because initially it became a bit of a feeding frenzy. But I can tell you, because it's not directly related, that there was, in a similar vein, a subpoena issued against Mvelapanda, where you will remember that Mr. Sehwale was the chairman of Mvelapanda, and his trust's a very large shareholder. And that was where the money was coming from in the marriage. Yeah. And so the subpoena was issued against the auditor of Mvelapanda to provide the financial records of the company. And the company brought an application to set aside that subpoena. But that, we've been fighting for 2 years, and it went as far as the Constitutional Court, and it was held that the company did have to provide all its financial records from inception. So that's thousands and thousands of pages that we've just received. But unfortunately, that's as far as it's got.
Yeah, and well, using that as an example, can divorce matters take that long before the courts? I mean, it's what,
4 years.
4 years now. And is it commonplace that they can go on for that long?
Tim, it's not commonplace and it shouldn't happen, but it certainly does happen. It depends on how obstructive your opponent is. If people are cooperative and people want to get things finished, then they can get things finished. They can get things finalized, settled very reasonably, very decently, with dignity, and quite amicably in many cases.
Now, I want to go back to the third-party subpoenas that we spoke about earlier on. That does it mean, therefore, that somebody who operates a company or has got an interest in a company or has a trust, for that matter, where they've got their assets kept and there are other parties there, that such trusts or companies can be, given this ruling, for instance, that they can have those trusts disclose how much money they have or what the value of the assets are?
Yeah, absolutely. It often would depend, obviously, on what you have to have a right.
Yes.
So if, for instance, you're a beneficiary of the trust,
Yeah.
then you have a right.
Mm-hmm.
If you are, if you believe that the trust is your spouse's alter ego,
Yeah.
so it's a sham trust, it's them in another guise, then again, you would have a right. It also would depend on how you married, whether you married in community of property or out of community of property.
But in South Africa, we've got different types of marriage agreements, right?
That's right.
If you can talk us through those marriage, the ones we spoke about in the Pietermaritzburg matter, for instance, would be in community of property, I presume. Out of property, or out of community, right?
It's slightly complicated.
Yes.
That's a very long marriage,
Yeah.
and for marriages that happened before 1984, where people are married out of community of property,
Yes.
the court really looks at what would be fair in
Yes.
such a long marriage.
Okay.
Should there be a redistribution, even though you married out of community?
So there's a bit of politics.
So,
I mean, in terms of redistribution. The moment we talk about
Yeah.
redistribution, is I think of
You think
how we work things in
Yeah.
South Africa.
Well, exactly. You see, so it's
can't
really
have
it's a
complete
human-
democracy
it's a human
and so
right.
on unless there's
Yeah.
a bit of redistribution.
And
Yeah,
so there should
sure.
be after a long marriage.
Yeah.
These days, you really have three systems. You either married in community of property,
Yeah.
where everything is shared, both your assets and liabilities, and you have one single joint estate.
Yeah.
And it's everything that you owned before the marriage or that you
Trusts
make during
or
the
no trusts
marriage.
or whatever.
Trusts are different.
Oh, okay.
But that's married in community of
Yeah,
property.
yeah.
Most people are married in community of
Yes.
property. That's our default.
Yes.
If, however, you go to an attorney before you get married and you say, want some advice, what should we do? They might say, no, you should get married out of community of property. That means you each have your own separate estates, and you can be married with accrual or without accrual. The accrual system means that everything that either of us makes during the marriage, through our own blood, sweat, and tears, so not through inheritance, but through our own blood, sweat, and tears, we should share.
Okay.
Because marriage is a partnership, and I might have supported you, I might have looked after the children while you went and earned the money, or vice versa. So that's the accrual system. Then if you're married out of community without the accrual system, that means that what's yours is yours and what's mine is mine. And that is obviously more unusual.
Okay.
Then once you are married, or before you're married, either party might set up a trust. And they might do so legitimately for estate planning purposes, so that the trust continues when you die, and your money goes into the trust. There are all sorts of laws involved in that. You can't simply donate millions of rand to a trust, for instance, because then you would have donations tax to pay.
Yeah.
But let's say you have a legitimately set up trust. That trust must be run properly as an independent entity that has the duty to grow the trust assets for the benefit of the beneficiaries. So you're supposed to have an independent trustee, not just family members. And the trust is supposed to be run properly with trustees, meetings, resolutions, financial records, etc. So every time you want to use money from a trust, it's not your own personal bank account, and it's not an ATM. And there should be a trustee's decision as to...
Now, Bev, if there's one thing that people must know or learn that is a common challenge facing those who are going through divorce, what will it be? If you were just to give one piece of advice for free.
Can I only give one?
Well, you can give more, but...
First of all, and so importantly, Tim, most people only understand their antenuptial contracts on the day they go and see the divorce lawyer.
Yes.
Understand what you are signing. Do
Yes.
not sign an
Yes.
antenuptial contract
Yeah.
unless you understand exactly what it means. Get independent legal advice. The other thing, if at all possible, remain transparent between each other during your marriage, financially transparent. Understand each other's financial affairs. And the third thing, if I could give advice to young women, don't become financially dependent. Retain some sort of financial independence so that you're not completely at the mercy of someone else when things go wrong, because unfortunately things do go wrong in about 60% of marriages.
Bev Clark, thank you very much.
Very nice to meet you. Thank you,
It was
Tim.
a pleasure talking to you. Well, there you are, and we explained the decision by the Pietermaritzburg High Court, but there are other challenges, implications elsewhere within the marriage laws of South Africa, and we hope that you found this discussion beneficial. And please write to us, give us feedback on the show about the topics that we are covering. You write to us. Email address is tonightwithtimmodise@gmail.com. We also welcome your comments on Twitter @timmodise.